Adriani. I'm Devyani Prabhat, Professor of Law at University of Bristol. I'm really delighted to be chairing this panel because we have some stellar speakers today who are involved in the actual challenges to detention procedures and have studied these and researched these. So it's really exciting to hear about their research. Our first two speakers are Maurizio Veglio and Ulrich Sege. They're from the International University College of Turin, and their paper is Lexillium, an insight of a legal failure. Maurizio Veglio is a clinical faculty member at the International University College of Turin. He's also a lawyer. He's admitted to the Turin bar, and he specializes in immigration law. Since 2011, he's a lecturer in human rights and migration law clinic, and he's the author of several articles and as well as books. His most recent book is La Malapena from 2020. It's really great to welcome you here, Maurizio. And with him, his co-speaker is Ulrich Sege, who's also in the same university. He's faculty member and director of the Clinical Legal Education Program. In 2017-2018, he was lecturer at the University of Territorial Law Clinic in South Africa, and he studied law in Germany, France, and Belgium. In addition to his academic role, he is also a practicing lawyer and a member of the Italian and German bars. He speaks on the subject widely. He's also been collaborating with the Italian Association for Juridical Studies and looking at migrants' rights on internal EU borders. So he's a founding member and executive secretary of the European Network for Clinical Education, and also really immersed in the migration as well as clinical education networks. So welcome, Ulrike, and the floor is now yours.
Thanks, Devyani. Thanks, Adriani, and everybody who was behind this event. We really feel the privilege and the very important opportunity to have this discussion with you and to learn from your experience as well. We need to start by saying that this very nice opportunity comes on the very moment of an unfortunate coincidence, because 2 days ago in the CPR in the Pre-Removal Detention Center in Turin, Italy, a 23 years old Guinean, a young man, committed suicide while detained in the solitary confinement. Far from being something which can be considered unexpected, this event is probably the strongest reminders for all of us to stress the importance of dealing with people's lives in detention. Of course, a number of events are about to take place in Italy as a reaction to what happened. But what we feel important is to underline the meaning of working on pre-removal detention centers, the meaning of working with protection of people, dignity, and people's lives. We are going to present our work in the, especially on the pre-removal detention center in Turin, which is in the north western part of Italy, close to the French border. And we are presenting what we have been working since a number of years now, and especially the focus of our attention, which is the local pre-removal detention center. I'm asking Uli if you can move on with the slides, please. What we started from is trying to challenge and unveil a lexical fraud, the manipulation of notions, of language, and of ideas. What you see here is the pre-removal detention center in Torino, how it looks like in the middle of the city, with high fences, 4 meters high fences, and segregation areas inside it. 2 examples of this lexical fraud I was mentioning before. The first one is the name under which one of the area is labeled. Next slide, please, Uli. You see in the highest side of the area, there are there's a number of solitary confinement cells, tiny cells. These places are called as a unit little hospital, which is extremely telling and eloquent, because there is absolutely no medical device inside this place. And this is also the farthest place inside the center from the doctor's office. Even though everybody, even detainees inside the center, calls it the little hospital. A second example comes from the name by which detainees are referred to by the people running the center, which is guest. A very, I would say, unusual kind of guest, a guest who is deprived of personal freedom, without, by the way, any criminal charge, a guest who is deprived of the liberty of using the exercise of his own rights in terms of communication, access to web, because all mobile phones are seized on entry by the authorities, a serious lack of basic services. The center can host up to 180 detainees, but at the same time, it is only granted service of one nurse 24 hours a day and one doctor only for 6 hours a day. So it is clearly evident the kind of affliction in which detainees are kept, are forced to be. And this is clearly one of the reasons that expose them to the temptation of self-harming, to transform their body into a mean of negotiation towards freedom, towards liberation. We really wanted to investigate the role of the judiciary and the legal chance to be released, if that was one of the reasons behind the high number of self-harm episodes, the high number of people trying to commit suicide or swallowing things or hurting themselves. We came to the conclusion, we're going to go through the project in a minute. We came to the conclusion that only in 5% of cases, detainees were actually released on the ground of a judicial decision. In all other situations, detention, the end of detention came as a result of the maximum period of detention being elapsed, or a release for health reasons. So our aim was to transform anecdotes, mainly coming from lawyers and from activists, individual accounts, mainly coming from lawyers and activists, into data, into statistics, into public and accessible information. And this is what Lexillium is all about. I'm leaving the floor to Uli for the next slides. Thank you.
Yeah, thank you, Maurizio, and I'm also glad to be here and to present you a bit more further the Lexillium project that has, as you will see a bit later, been running for several years, but already some years back. The project itself was a so-called monitoring center for judicial control of migrants removal, and this implies also the detention decisions. It was specifically, as Maurizio highlighted, triggered by our understanding that came a bit more anecdotically by the legal practice we observed, that actually a judicial review on the detention decisions as such and the removal decision is in practice very meaningless, because it doesn't really come to a specific effective control about the conditions to be detained or not. So we looked specifically on this judicial review from the so-called justice of the peace, the judicial departure, how they called it in Italy, which has been, it's an institution that has been installed for minors to solve minor cases, so small cases, small claim cases, and for I guess political reasons, it has been also given the authority to decide on specifically immigration matters as well. So we came to analyze around 1,200 decisions in different places. You can see it in different places in Italy. Some of them, Rome and Turin, in particular, those times, very specific areas of detention centers, which are very strongly functioning at those times. We're talking about years back already. So the decision was the project run in 2000, started in 2013, but run really in 2014, 15, and 16. Unfortunately, for funding reasons, we had to close this activity, which and that will I will come to it in the conclusion somehow. Is something which, in our view, is something unfortunately, and I will talk about this in the conclusion a bit more. The research was coordinated by the law clinic of the University of Roma Tre, and Enrica Rigo, who I think she will speak this afternoon or tomorrow, I can't remember, at this conference as well, has been a bit the sort of guiding mother of the project somehow, and we involve different law clinics of different universities and researchers in this project, together also with ASCI, this Association of Legal Studies for on Immigration. What we did was we really had quite a hard time actually to get access to the paper documents, meaning the court decisions of the judicial departure and the court minutes, and we went to the archives, scanned them, and afterwards the different research teams in different local areas analyzed them and put them into the platform, which unfortunately you see the platform as a website over there. Unfortunately, at the moment, due to some server problems, this platform is not available, but will be available soon again. We had, you can visit and see all the decisions scanned, anonymized, obviously, but you can see some of those decisions as a very specific example of how this judicial control is functioning. What is very interesting is, and was very hard, is actually to get access to these judicial archives, because of the fact that there are had some really somehow resistance by the judicial departure system. I give it back to Maurizio, who will introduce you some of the outcomes of this project in more detail.
Thanks, Uli. So trying to sum up the outcomes that we came to collect, to gather. The results of the search has been interesting and has been impressively disappointing in the quality of the jurisdiction. Both performances from judges and lawyers are, I would say, far below the expected threshold. A first consideration on the place, or basically all hearings took place inside detention centers, while according to the Italian constitution, places that are devoted to judiciary are those managed by the Ministry of Justice, not the Ministry of Interior. Even more astounding is that those places are highly patrolled by police and highly surveilled, and see the presence of arms, weapons. So it is already something which forces the idea of a judicial whole or a judicial procedure taking place in such an environment. Data shows a clear inadequacy in the quality of the case law, starting from the length of hearings. Considering Torino especially, half of the validation hearings and 80% of extension hearings lasted less than 5 minutes, which means 300 seconds, which is quite striking if we remember that the matter, the core of the decision is personal freedom and deprivation of personal liberty. Decisions from judges are usually lacking legal reasoning, are usually lacking a specific reply to legal arguments from lawyers. But at the same time, we need to consider that in Torino as well, around 50% of transcripts of hearings show no legal reasoning from lawyers as well. So it's a very disappointing panorama. Most of the decisions from judges are actually only a tick on a box of a pre-printed template with no individual elaboration and no individual reasoning from judges. And if you see the stats in the slides, you will easily understand why validation and extensions rates are so high. And Torino is the peak of this phenomenon. If you see 98% and 97%, means that basically, going back to the start of this discussion, the chance of being released by the pre-removal detention centers out of a judicial decision is basically non-existing for detainees. I'm leaving the floor to Uli for the last consideration. Thank you.
It will be very quick. This kind of outcome just present the failure of a legal system who is not providing an effective remedy against detention orders. I think it is quite crucial to think of, as soon as you take somebody's liberty, and this is our human rights system now in particular, you would also provide an effective control about those detention orders. And I think this is something which is obviously here very strikingly missing. This violation puts in question the entire and the very existence of such a detention system. And this came very strikingly, specifically in this area of pandemic, where out of legal provisions, and I'm quoting here Article 15 of the Return Directive in particular, given the little prospect of return of those people detained, that you would not have the right to confirm legally a detention order, while at the same time, at least the example of Italy has shown that a lot of detention orders have been confirmed without any questioning. So by that saying, I would like to just to finish and saying, obviously this shows that another piece of the violence, the judicial violence to some extent, that we can observe in the detention systems. Thank you very much.
Thank you very much. That is a really enlightening, even if depressing piece, because as a lawyer, I'm really sad about the kind of statistics that you have, but I'm hoping to discuss more in the Q&A about all the findings that you have found. And thank you, Maurizio, Ulrich, for coming here, and also for brilliant sticking to the time from both of you. Thank you so much for that. We move over from Italy to Greece now, and we have with us today Alexandros Konstantinou, who is a lawyer and who works a specialist in human rights and refugee law. He has a master's degree in human rights from the University of Strasbourg and a master's degree in sociology of law from the University of Athens. Since 2011, he is working as a member of the legal unit of the Greek Council for Refugees, and he's coordinating GCR's detention team, and which is dedicated to the provision of legal aid to persons in immigration detention. He has also worked with the National Commission for Human Rights and the Office of Secretary General for Migration, and he has been an invited speaker in many conferences and trainings and published articles widely. Since 2017, he's a member of the Greek National Commission for Human Rights. So he's going to talk about administrative discretion, limited judicial scrutiny, which is really carrying on with the themes from our first paper. So welcome, Alexandros, and the floor is yours.
So thank you very much. Thank you for the invitation, and congratulations for the whole organization initiative. I think that I will continue from the point that the colleagues from Italy have just stopped. I mean that it's quite impressive how similar are the situation in both countries, but I think that the situation in Greece is a little bit it's a little bit different from an institutional approach. I will speak for the issue of the lawfulness of the detention of third country nationals, and in particular for the large administrative discretion that is provided to the police in order to detain, and also the limited judicial scrutiny of the detention orders. I have three basic remarks that I will develop below. The first is that the Greek legal framework provides a very large discretion, I would say an absolute discretion, to the Greek administration, to the police, in order to impose a detention order, a detention measure. That secondly, the police use this discretion in a way that is, at least to say, controversial if it's not arbitrary. And third, that the courts, they do not always examine in depth the lawfulness of the detention order, which is a problem that has to do with the scope of the judicial scrutiny, but also a problem per se of the lawfulness of the detention according to Article 5.4 of the European Convention on Human Rights. So to begin with, I want to say that in Greece, the detention order, according to the Greek law, is imposed solely on the basis of a decision of the administration, decision of the police, and there is no requirement that this decision should be examined or approved by the court. So it is the initial decision imposing the detention. It is a decision that is based, it's on the hand of the police, and there is no safeguard that this decision will be examined by an independent body, by a judicial procedure. So, and this is, to my view, this means that the Greek law gives an absolute discretion to the Greek administration in order to impose a detention measure, and an absolute power to detain third country nationals in view of removal or in view of the asylum procedures. This is more worse because as it has been, first of all, we don't have a free legal aid system, and as, for example, the CPT found and repeatedly found in the more recent reports, due to the lack of a free legal aid system, in practice, access to courts, it's theoretical and illusory for the majority of persons detention, and that means that people will stay for the initial detention period in detention without having the possibility to access to justice. For the asylum seekers, this period can be up to 50 days. For people under removal procedures, this period can be up to 6 months, meaning that these people are deprived for this period from their liberty on the basis of a decision of the administration. And there is a certain safeguard on the Greek law that it comes from the EU law. There's the obligation of the ex officio examination of the decision prolonging the detention or the decision imposing the detention, but the one that is issued after the initial period, meaning after the 50 days for the asylum seekers, or after the 6 months for person in removal procedures. So there is a requirement of an ex officio judicial examination of this decision. However, the data that we do have from the Athens Administrative Court, for example, they're really disappointed. I just want to say, and maybe this is worse from what the colleagues from Italy said before, that, for example, that the majority of the decisions that they have been transmitted to the Athens Administrative Court for the ex officio judicial examination of the prolongation of the detention decision, all of the decisions, they have been approved by the court. There have been not even one case that the court disapproved the extension of the detention order. That it was the number was 846 cases, and that was also happened the previous year in 2019. Out of the 683 decisions that they have been transmitted to the Administrative Court of Athens in order the court to ex officio examine the lawfulness of the detention order and to rule if the court approves or not the extension, the prolongation of the detention. It was only 3 cases that the court did not approve. This is something below 1%. It's 0.4% of the cases that have not been approved. So this shows that we do have a system that it's, from the very beginning, it's lacking of adequate safeguards in order to protect people that can be subject to migration detention from arbitrariness. On the top of that, it's not only that the police has a very large discretion to detain third country nationals, but it's also, as it is widely documented, the police use this discretion in a way that it's, at least to say, controversial. For example, the Greek Ombudsman constantly found that there is a widespread use of doubtful administrative practices. The UN Working Group on Arbitrary Detention recently, in its report that has been published in 2020, found that there are problems that could lead to arbitrary and prolonged deprivation of liberty, including the lack of an adequate individual assessment. And the CPT, in its latest report, called the Greek authorities to reconsider the approach they have for migration detention and to reform their immigration system. The CPT also said that you may know that Greece is the only country that the public statement by the CPT has been issued back in 2011, the only EU country that the public statement of the CPT has been issued in 2011, which is a quite vocal measure on behalf of the committee. The CPT warned the Greek authorities on its last report that they don't want to take again this road, which leads to the opening of the procedure for the issuance of a public statement, which, to my view, ring an alarm on what is happening on the field. As I said before, it's not only the fact that the police has the discretion to detain, the large discretion to detain, but the police use it in a way which is in a significant number of cases, it could be considered as arbitrary. I will just say some examples to give you an idea of how this power to detain is used by the police. We do have practices. First of all, we do have a lack of individual assessment. There is a lack of due diligence. In cases people are detained for prolonged periods without any action to be taken for the case, or by facing very prolonged delays in the procedure. We do have an extensive use of public order grounds, which are not properly justified, or they are justified on infringements like the illegal entry of people who are in need of international protection, for example. We do have detention of people for whom the removal is not feasible, and this has to do with the implementation of the EU-Turkey statement, which in practice since March 2020, there is no readmission to Turkey. However, people 1 year, more than 1 year since the suspension of transfers to Turkey, they are still detained with a view of the execution of the readmission to Turkey. We do have detention upon arrival. This is in particular the case of Kos Island. And this is something which, to my view, is quite impressive, because this happened just because the Minister of Migration and Asylum visited Kos on the beginning of 2020, in January 2020, and made a statement saying that from now on, every new arrived person in Kos will be detained in the pre-removal detention facility, and then we have a switch on the administrative practice, just like that, without changing the law. This is very this shows in a very characteristic way how the administration understands the legal terms and the terms of the law with regard to detention. And we have lack of procedural guarantees of those detained, meaning that decisions are not always communicated to detainees, that people, they don't have any access to translation service, so they do not understand the documents, they don't have access to legal aid, and so on. So this is more or less what I described in the beginning at what is the administrative discretion with regard to the imposition of the detention of third country nationals. And it's really important to see what courts do in the cases of legal remedies submitted, apart from the ex officio examination of the prolongation of the detention, to which I mentioned before, to which I referred before. There is also, of course, the possibility to submit a legal remedy before a court and the person to ask to be released from detention. I would also say that there are some structural issues that they undermine the quality of the legal remedy and of the examination before the courts. The colleagues from Italy said before that hearings are taking place inside the pre-removal detention facilities. In Greece, as a rule, the hearing is taking place without the presence of the detainee, meaning that the judge will never see the person. He or she will only see the lawyer of the person, and also the administration is never present. The administration just send the written stereotypical decisions on detention. They're never present to support their arguments. And of course, there is no possibility of an appeal against a negative court decision, meaning that this is a single instance procedure. And after that, the person does not have any other domestic remedy in order to challenge his or her detention. Apart from these structural issues that have to do with the effectiveness of the remedy, and I will just now say that in highlights, as I have something like 4 minutes. I just want to say that we do see in cases that we do support that the major issues that they undermine the effectiveness of the remedy is first that we do have a lack of coherence and a lack of legal certainty of the case law of the Greek courts on detention. I mean that we have contradicting decisions. We have decisions ruling in a contradictory way on the same legal issues, on the same factual issues. We do have misinterpretation of the contra legem, I would say, interpretation of the provisions of the domestic legal framework, but also of the CJEU and the GNCHR case law. We do have there is the tendency to the Greek courts to, at least in a number of cases, to the examination of the lawfulness of the detention to turns into an examination of the risk of absconding. So the requirement in order the remedy to be accepted is the person not to present a risk of absconding, irrespective of the other issues of lawfulness of the detention order. And the risk of absconding for the Greek courts means the person to have the possibility to provide a fixed address and means of subsistences and the social bonds with the country, which is something that a newly arrived person, for example, in need of international protection, is very difficult to provide. And also we do have a minimum or limited examination of the detention conditions, which is quite impressive. But detention condition is one of the most and well-documented issues with regard to detention in Greece. Just to give you an example, there is a pattern of rejecting such allegations by considering them as vague and non-proven, even in cases that the person is detained for many months in a police station. We do have cases of persons that they stay 12 months in detention in a police station, and the court did not accept the allegation for the detention conditions. So I think that this is more or less the environment that the immigration detention is applied in Greece. But just a final remark, I want to say that it's not only an issue of the discretion of the administration and also of a certain limited judicial control that undermines the basic safeguards of third country nationals in the country. It is also the law as such that it's highly problematic. I mean, since 2019, we do have a dramatic amendment of the legal framework with regard the detention of asylum seekers and persons in removal procedures. And just to give you two examples, the new law on the detention of asylum seekers is now allowing the detention for a period up to 36 months in total for those who apply for asylum, not only while in detention, but also while at liberty and then are detained. And the relevant law transposing the return directive in Greece has also been amended in 2020. And now the new law has reversed the obligation to examine alternatives to detention before applying a detention measure, meaning that the new law say that any third country national who is in a removal procedure can be detained, and alternatives to detention will only be examined in an exceptional basis. This is a full reverse of the principle that detention should not be applied, should be applied as a last resort. And of course, it's not in line with the EU directive on returns. I think that these changes on the legislation have really aggravated the situation. This have led to prolonged detentions in an environment, as described before, that is lacking of basic safeguards. But I think that they also show the political will to apply a policy, a migration management policy that it's really based on the application of indiscriminate detention against the newly, but not only newly arrived persons. So thank you very much.
Thank you so much, Alexandros. And it's really interesting that we've seen the proceedings, and we've seen the judicial angle, the administrative decision making, and the inconsistencies in all these places through the lens of the law, and how that is recreating the conditions of violence on people in detention. Thank you very much for that. For our next paper, we're still in Greece. And in fact, now the question is, the proceeding, is this, what is this kind of proceeding? If it's not a detention proceeding, what is it? And for this question, we have with us Ioannis Papadopoulos from the Institute of Criminal Justice Studies of University of Portsmouth, UK. And Ioannis is going to look at the detention processes for unaccompanied minors in Greece. He is somebody who has done his law degree in Aristotle University, Greece, but then his postgraduate studies in the Netherlands at the Maastricht University, and then the PhD from the University of Portsmouth, UK. His research is very much about the rights of the child and looking at the situation of unaccompanied minors. So he has developed expertise in this area, not only through his academic connections, but by also working with international international and Greek humanitarian organizations that work with children who are in this situation, and his work to provide legal support and counseling on asylum procedures and child protection issues to migrants who are in this situation. He's a member of the ESC Working Group on Immigration, Crime and Citizenship and co-chair of the ESC Qualitative Research Methodologies and Epistemologies Working Group, as well as being a member of the editorial board for the Journal of Qualitative Criminal Justice and Criminology. So welcome, Ioannis, and we look forward to your paper.
Thank you so much. I hope you can hear me well. Give me one moment to share my screen. Excellent. And I believe you can see my screen now, hopefully. Can you see my screen? Okay, yes, excellent, great, thank you. Hello, thank you so much for being here today. My name is Ioannis Papadopoulos. I've been practicing law for the past decade or so, specializing on unaccompanied children and their positionality within the Greek context. Today, I will be sharing a part of my recently completed PhD research, which was based on exploring detention processes for unaccompanied minors in Greece. So with no further ado, I always like to start my presentations by briefly analyzing the term unaccompanied minors. I'm going to briefly repeat what the United Nations High Commissioner of Refugees specifically defines as unaccompanied children, which are children below the age of 18, not being cared for by an adult who by law or custom is responsible to do so, and obviously separated from their parents or from previous legal or customary caregivers. Despite the pretty straightforward terminology of the High Commissioner of Refugees, I always keep in mind the European Council's definitions specifically states that unaccompanied children are not just the minors who arrive at the borders alone and enter the host country alone, but also the children that are left alone right after crossing the borders of the host country, in this case, Greece. In their majority, unaccompanied children originate from countries that are severely affected by forced migration, warfare activities, and a clearly unstable socio-political regime, for which reason there is a general consensus both in literature and research that this group is the most vulnerable of all individuals seeking safety in foreign countries. Currently in Greece, according to the law, unaccompanied children could be located either at the national borders, where the reception and identification centers are located, or in the mainland. In the first case scenario, state authorities are expected to confirm that indeed the individual is an unaccompanied child, in which case the competent public prosecutor is to be informed, because according to the law, the public prosecutor is a temporary guardian of the child until the child is transferred to official accommodation, where again, expecting to transfer the guardianship of the child eventually. During that time, children are to be provided with reception identification procedures, to be subjected to these procedures, which include psychosocial support, legal aid, and in some cases, age assessment procedures. However, if children somehow manage to cross the borders without being spotted and they end up in the mainland, the same process applies. Only in this case, police authorities are expected to follow the same procedure, which, as we will see in the next couple of slides, is not always entirely successful. As regards the irregular entry in Greece, according to the law, the current context does not make any differentiation between adults and minors as regards the issue of arrest and prosecution for illegal entry. According to the law in Greece, anyone attempting to enter the Greek territory, or even successfully entering the Greek territory without legal formalities, so irregularly, is to be punished by imprisonment of at least 3 months, so that is 3 months to 5 years, and a penalty of at least 1.5 thousand euros, unless the individual decides to apply for international protection procedures, which we will be discussing in a bit. Second step would involve detention processes, and specifically in the case of unaccompanied children, UAM, unaccompanied minors, protective custody or custodial measures of a protective character, if you may. And step 3 would involve deportation unless the individual decides to apply for voluntary departure procedures. Especially in the case of unaccompanied children, what is interesting, what I kept asking myself throughout my doctoral studies was this. According to the law, we know what the law states, but in practice, we notice that unaccompanied children, after they enter the country irregularly, they're supposedly placed in custody of a protective character, but eventually children somehow end up in a detention context, which is highly inappropriate as regards their interests or their care and support that they are entitled to, which raises an obvious question. do unaccompanied children become gradually part of the immigration debate through the context of detention which they experience, which I kept asking myself throughout my studies, and this is what I tried to answer during my PhD research. First things first, according to the Greek Ombudsman and the High Commissioner of Refugees of the United Nations, unaccompanied children seeking asylum should never be held detained for entering the country illegally, which is pretty well known so far. Keep that in mind, along with the Geneva Convention specifically stating that asylum seekers should not be prosecuted for illegal entry, which basically means that legal penalties may be imposed only after an application for international protection has been definitively rejected. Currently in Greece, detention for unaccompanied children is allowed, and you can see in the parentheses the plethora of legislation on the issue. It is still allowed as a measure of last resort only for 25 days pending referral to more appropriate and child-friendly accommodation facilities. It used to allow children to experience an additional 20-day period if appropriate accommodation was not found or available at the end of the first 25-day period, but this provision was cancelled by recently issued legal act in Greece. During that time, unaccompanied children are to be kept separately from adults, to experience and be part of child-appropriate activities with access to education, social legal support, psychosocial services, with their age and vulnerability, as well as their best interests, according to Article 3 of the Convention on the Rights of the Child, to be taken into consideration at all times. At the same time, the law specifically states that as soon as an unaccompanied child enters the country irregularly, these children are to be placed in special centers for the accommodation of minors or in any other suitable accommodation facility available for children. However, due to the lack of adequate and accommodation that arrived for the past 7, 8 years or even a decade, we witness children being placed in detention facilities, pre-removal centers, or even police stations, where they are subjected to a wide spectrum of human rights violations, including at the sharp end, multiple expressions of violence. As Alexandros correctly mentioned before, they experience prolonged detention, and in some cases, children indirectly are prevented from submitting asylum requests because somehow they know that somehow by submitting asylum requests, this would lead to a prolonged detention. So one of my conclusions on my PhD was that protective custody or custody of a protective character for unaccompanied children in Greece is not being used as an excuse for detention, and that there certainly is not a matter of prioritization of detention over protective custody, but it is the lack of adequate and appropriate accommodation that eventually causes detention to be misinterpreted wrongfully as protective custody, which leads to the obvious question: are detained unaccompanied children considered to be part of the immigration debate? Now, immigration debate remains largely fairly recent and largely abstract topic. Despite the current research on the various forms of immigration on legislative level, including the criminalization of illegal entry or stay, as well as issues of administrative detention and deportation on the basis of individual criminal background, as a researcher, I noticed that there was no question ever raised with regard to the positionality of unaccompanied minors in Greece within the immigration debate, as regards the fact that they are being apprehended and placed in detention as if they had committed an actual crime punishable by law. Unaccompanied children in Greece have a unique status brought about by the criminalization of a social policy imperative. As detainees, they are not to be punished or experience moral condemnation, since they were never convicted under the relevant criminal law provisions. Rather, it is due to the country's inability to provide them with sufficient, ample, adequate, and proper accommodation, as the law originally intended, the protective environment as mentioned earlier, that eventually causes Greece to resort to a de facto use of criminal justice facilities and a de facto criminalization of unaccompanied children overall, which is in direct contravention to the CRC. Obviously, this leads to the question on whether or not this form of detention is legal or not. So how does legality of detention combine or connect to the immigration debate? Which brings me to one of the theories which I developed as a doctoral candidate, which I like to call the vicious circle of UAM detention. Now, bear with me on this one. We have unaccompanied children on one hand, that as soon as they cross the borders of the country regularly, they are to be placed in a protective environment where they should be receiving custodial measures of protective character. Unfortunately, these children end up in detention facilities being subjected to highly inappropriate, unsuited, and certainly not child-friendly detention processes. At the same time, we have the best interest of the child principle that is expected to apply at all times, and Article 12 of the CRC on the right of children to be heard in all judicial and administrative proceedings, more specifically according to paragraph 2 of Article 12. So what I kept looking for and what I kept researching in was the type of detention that these children currently experience. I was trying to figure out if this form of detention that children were being subjected to, unaccompanied children were being subjected to, was a part of the judicial or administrative proceedings as stipulated in Article 12 of the Convention on the Rights of the Child. Because if so, children should have been provided with the right to be heard during these proceedings, and maybe also question these proceedings if they had the right to. Otherwise, if there's not a part that would somehow be part of Article 12 of the Convention on the Rights of the Child, what sort of detention is this? The question therefore still stands: how can detained unaccompanied children eventually be heard during this form of detention? And the solution would be only through qualitative research. I'm not going to go into deep about qualitative aspects of my methodology, of the methodology I used, I applied in my research, but I briefly want to mention that the main aim of my project was to focus attention, resources, and findings in order to highlight the need to establish minimum standards as regards CRC implementation in Greece, and that by conducting in-depth examinations of the participants' personal lived experiences within detention centers, not just unaccompanied children, but also practitioners working in the humanitarian context, and also focus on how participants make sense of that personal experience within detention, thus allowing me to examine indirectly and also directly in some cases the legality of detention. The only way to do that would be through phenomenology. So for someone with a strictly legal background, it was quite interesting to apply phenomenological research in this combination of criminological and socio-legal analysis, which I conducted in my research. The main aim has always been to enable stories to be told directly from unaccompanied children and practitioners as regards the conditions in detention. And for this reason, I applied the double hermeneutic process of IPA, according to which the researcher, in this case myself, is expected to try and understand the participants, trying to understand their own experiences as detainees. So by introducing phenomenology in migration studies, I tried to articulate the experiences of participants and create a chain of connection between embodied experience and how participants make sense of this particular experience. After completing the audio recorded interviews and transcribing the results, I identified common references and created a phenomenological link among the participants' responses, which consequently led to the creation of superordinate and ordinate themes based on similarities among responses according to the IPA methodology. The result allowed me to create 4 superordinate themes which focused on hygiene concerns of participants, on the overall detention setting, on services provided within detention facilities, and also incidents of abusive treatment, both verbal, physical, and at some points sexual as well. I'm not going to be sharing quotes of participants at this moment. I wish I had more time for that, but I want to add some focus to the next slide, which is kind of interesting. For the past 6 months, yes, 6 months or so, or maybe 7 months, every professional working in the humanitarian sector in Greece, we are all asking ourselves the same question. Does Greece cross the threshold to a new era? And what I mean by that is that in December 2020, the Greek state announced the abolishment of protective custody for unaccompanied children, which was long awaited and, to be honest, expected. According to the new law, children are to be transferred directly from reception and identification centers and police stations directly to appropriate and child-friendly hosting facilities in the mainland without having to go through detention processes the same way they have been going through detention for the past decade or so. And the obvious question is how? Because we're mentioning an issue that has been the main problem of child protection programs in Greece for the past decade or so. The response that we indirectly received from the government was that there will be a national tracing and protection mechanism for unaccompanied children in precarious conditions that would be based around the establishment of a tracing and protection team and tracing line, which would accept referrals on a 24-hour basis, so that children are immediately transferred to secure emergency hosting structures, which are still expected to be fully operational, hopefully by the end of this week. We'll just have to see. In these emergency facilities, children would be temporarily placed and hosted and supported, and they will be the recipients of psychosocial support, interpretation services, or even medical aid as well. This is what we know so far. However, it's clear that Greece still suffers from a poorly structured legal and procedural framework, and I'm saying that because the new law, even though it's pretty straightforward as regards the abolishment of protective custody, lacks clarity concerning unaccompanied children who are already subjected to protective custody measures, so children that are already in detention facilities at the moment and police stations at the moment. And most importantly, there are no indicators or guarantees as regards legal support. The announcement mentions psychosocial support or even medical aid, but no references are made as regards legal support throughout this process when children are located, subjected to reception procedures, and then directly referred and placed in this sort of temporary accommodation facilities. So what we know so far, and we're sure of that, is that by the end of the year, we will certainly have lots to talk about. And the only way to examine whether or not the new law will be properly and correctly applied in practice would be only through qualitative research, which would again allow us to analyze participants' experiences of this new law, so that we can explore the legality of detention processes and examine the inconsistencies between law and practice. Interestingly enough, the new law, an announcement made by the government mentioned that until the new law is put into actual practice, the police is still going to assist the state towards this goal and this aim, which is to remove children from detention. But for someone who has been working in the humanitarian context, this does not introduce anything new, because we basically say that the same context will keep on happening until something changes, but no one knows exactly when this new law will be put into actual practice. So through qualitative research, it would be the best solution for us to adjust national policies, introduce advanced frameworks, facilitate the adjustment and integration, not just of the CRC provisions, but also of the newly stated law, so that we can eventually put the best interest of the child into actual practice, instead of keeping it as a simple de jure doctrine. I want to thank you for your time. I consider it an honor to be part of such an insightful, interesting conference. It's been a great 2 days so far. Can't wait for the rest. And I'm open to any questions you might have at the end of the conference. Thank you.
Thank you so much, Ioannis. And I think it was amazing, not only just the legal aspects of what you spoke about, but also the kind of qualitative research that you've been doing. So I hope we'll get to discuss that as well in the Q&A. That brings us very much to the last speaker in this panel, who is Sangeetha Iengar, who's a barrister with Goldsmith Chambers. She's going to talk about the legal architecture of immigration detention and ask the question if it's a house of cards. Sangeetha is an award-winning public international barrister. She specializes in asylum, immigration, and international human rights. And she's given a TED talk recently on on migrants and how refugee law is used to trial oppressive measures and policies. She's also led a 2-year-long European Commission project to look at how to improve access to fundamental rights for undocumented children and families across Europe. She's published a book which has really broadened the discourse on irregular migration within European institutions, and she has experienced some of the humanitarian crisis that people are fleeing from firsthand, because she has worked as a justice sector development consultant and has viewed how the position has shifted in European courts with respect to, reception countries in Europe and how the situation has been changing. So she's also a director of the board of Phoenix Humanitarian Legal Aid, an NGO which provides pro bono legal services to asylum seekers in Lesbos. And Sangeetha is currently working on a project in which she's examining how European states weaponize the legal right to asylum, which is obviously extremely topical right now, and also how the European border policies are constantly at war with international law and human rights law. So in her current paper, she's going to talk about some of those aspects. Sangeetha, we can't wait to hear you. The floor is yours.
Devyani, thank you very much, and thank you to all my colleagues also for their insight. I hope to zoom out and provide a sort of international framework from which we can interrogate the national examples. I'm also going to stop my video to try and correct the frailties of my internet. So I will just stop that and start sharing the presentation, which I hope will begin. So we start with the fact that immigration detention has become commonplace. This is not a novel point for any of us to hear at the moment. It's popular the world over. We're used to hearing of these public estates being managed by private corporations and their squalid conditions, and they range from what I call the Russian doll of detention, a cell within a camp on an island like in Papua New Guinea, to vast detention estates in the US where children are detained and caged and forced to give evidence without legal representation. But as the phenomenon grows and adapts and becomes more pervasive, I'd like to delve back into the legal mechanics now, the nuts and bolts of the legal architecture that underpin immigration detention, to bring it back to when it can be lawful, and hopefully in doing so, rebuild in all of our minds what I hope will be a useful legal architecture upon which to interrogate those instances of national detention that my colleagues have spoken about today. So what is it in law? And I will make this a whistle-stop tour because I can see that time is definitely against us at the moment. Starting from a very non-contentious neutral definition as the founding block of this architecture, immigration detention is the deprivation of a non-citizen's liberty for reasons related to their immigration status. It's an administrative measure, tends not to engage the judiciary, and it's ordered by the executive, so executive detention. It can also, and one of my colleagues has spoken about this, fall under the remit of criminal justice, where migrants are criminalized for irregular entry and then convicted and sentenced of a criminal offense. Not something I'll be focusing on specifically today. But in terms of the international framework, there are really two opposing sides of the coin that we start with. Firstly, on the one side, that immigration detention is not de facto prohibited under international law. Therefore, there must exist some examples that are lawful and rights compliant. And secondly, that there is no one international treaty governing the human rights of people in immigration detention. So the result being that immigration detention often, frequently, as we've heard, exists at the edges of lawfulness. And it takes protracted litigation through numerous different instruments to sharpen the edges of that legal framework. So does that mean that there isn't really a legal framework, that it's a house of cards falling in on itself? To answer that question, we look at the legal framework that does exist, which demonstrates that immigration detention doesn't exist in a vacuum. We have binding international and regional instruments, which I'll quickly take us through, declarations, resolutions, and other soft law instruments, and specifically the recommendations of treaty bodies, which I'll focus on today, committees of independent experts that monitor the implementation of core international human rights treaties, from which we can build a legal architecture to interrogate this phenomenon. And the instruments can be divided into two: those that address the conditions of detention and those that address the substantive lawfulness of detention. And I'm concerned with the latter of those two, as I think it's important to see just how far the boundary is being pushed and whether our legal framework is actually keeping up with it. So, of course, the primary right we're concerned with when we speak of immigration detention is the right to liberty. Articles, and I've laid them out, 9.1 of the ICCPR, 16.1 of the International Convention on the Protection of the Rights of All Migrant Workers, and Article 9 of the Universal Declaration of Human Rights, are all construed in similar terms and provide that Everyone has the right to liberty and security of person. No one shall be subject to arbitrary arrest or detention. And we have confirmation from the Human Rights Committee in their general comment, number 8, that this applies to instances of immigration detention as well. So again, not existing in a vacuum. But what makes immigration detention arbitrary and so unlawful? We've heard certainly instances in Italy and Greece today. There isn't any one universal definition of arbitrariness, but it has been looked at by a wide number of treaty bodies, and this helps us bring in the factors that would make immigration detention lawful. So starting firstly with the Human Rights Committee, the CCPR, which monitors the implementation of the ICCPR, in their now very old communication focusing on Australia, and quite a lot of this talk will focus on Australia for very obvious reasons, the committee looked at the case of a Cambodian national who was detained at various sites in Australia. And it was argued on his behalf that his detention and the detention of boat people more generally was arbitrary and contrary to Article 9 because of its inappropriateness, injustice, and its lack of predictability. The sole purpose of mandatory detention being deterrence. Now, the committee in this case, finding for the client, found that detention for a period of 4 years was arbitrary and used the language of necessity and proportionality to define arbitrariness. Moving on from that and building on that, we have the Working Group on Arbitrary Detention in its report of 2011, finding that detention may be arbitrary where there is no possibility for legal recourse, administrative or judicial review or remedy. And we heard from our colleagues from Torino that there has been instances of, I think they use the term judicial violence. And what is key here is that these administrative or judicial remedies have to also be effective and accessible. So we already understand from this starting point that in order for detention not to be arbitrary, it must be necessary, proportionate, and subjects must have the opportunity for redress. But what do we mean by necessary and proportionate? The Working Group on Arbitrary Detention and the Human Rights Committee, and I've laid these out, so I won't take us through all of these quotes in full, so I'm very well aware of the time. But briefly, we know that detention cannot be applied in a systematic or mandatory way as a migration control measure. So I think back to that 97 comment on Australia, where the mandatory detention of boat people occurred. We know that because the decision to detain must consider relevant facts on a case-by-case basis, it requires an individual assessment. That detention should be the exception, not the rule, which is not what we've heard is happening in Greece from our colleagues, and should not be imposed where there are non-custodial alternatives. It should be imposed as a last resort. So with both the Working Group on Arbitrary Detention and the Human Rights Committee, we're getting much more specific than the 1997 decision on the detention of boat people in Australia. But perhaps the clearest articulation of the confines of necessity and proportionality is articulated by the Special Rapporteur on human rights, on the human rights of migrants, who says that governments have an obligation to establish, firstly, a presumption in favor of liberty, secondly, to consider alternatives to non-custodial measures, thirdly, to proceed to an individual assessment, and to choose the least intrusive or restrictive measure. So deterrence forms no part of this equation on lawfulness. Now, lawfulness also requires something additional to all of these points, which is for the grounds for detention to be clearly defined and prescribed in legislation, a point which the Committee on Migrant Workers has repeatedly considered, as has the Working Group on Arbitrary Detention and the Human Rights Committee. This so far considers immigration detention in broad terms, so immigration detention covering the detention of migrants, but we also have to bear in mind the bite of Article 31 of the Refugee Convention, which prohibits states from penalizing asylum seekers for their entry and stay under refugee law. So in the case of asylum seekers and refugees, we then look to the UNHCR, who have published an exhausted list of lawful grounds justifying the detention of asylum seekers, firstly in their 1986 EXCOM document, and then more recently in their 2012 guidelines, which lay out 10 fundamental guidelines for the detention of asylum seekers, including that detention must not be discriminatory, that indefinite detention is arbitrary, and maximum limits on detention should be established in law. But of course, these are only guidelines. So we continue to have states like the UK, where I practice, which do detain indefinitely, notwithstanding these very clear articulated guidelines. As well as being prescribed by law, and I hope this helps as we look again at, from our colleagues in Torino and their example of what happens, one must have access to the law for the detention to not be arbitrary. That is, access to adequate and effective remedies. And the starting point here is the UN body of principles for the protection of all persons under any form of detention or imprisonment. And again, the special rapporteur here reminds us that these principles do apply to immigration detainees. They are, very briefly, access to legal information, access to legal assistance, and linguistic assistance. Something we've heard from Greece is already not happening. But again, this notion has been debated by the treaty bodies CAT in 2007, the Human Rights Committee more recently in relation to Malta, and they both articulate recommendations beyond the principles, so calling for a periodical review of detention, so an automatic review of detention where judicial review isn't available, to ensure that it continues to be necessary and proportionate on an individual basis, and crucially, enshrines the right to compensation where unlawful detention occurs. So with this, we have the backbone of the legal architecture. Whilst not codified in one neat treaty, we have binding legal obligations, comment that confirms that applicability to the immigration context, and lively debate amongst experts in relation to cases before the committees to scrutinize the factors required to make immigration detention lawful. So there is a framework, and on the treaty body's observations, it doesn't appear to be a house of cards in conventional contexts, but, and of course there had to be a but, what about more recent trends in immigration detention? How do they fit into the legal architecture on immigration detention? Now, I touch here on extraterritorial detention, a trend popularized by Australia, but I fear is just providing inspiration for other countries, specifically the UK at the moment. It's also known as offshoring detention, where people seeking to claim asylum in Australia and arrive by boat are automatically transferred to and held in processing centres in another country at the expense and control of Australia, but offshored for extraterritorial processing. So very much out of sight, out of mind. And in again, the Australian context, since 2012, those who arrive by boat without valid visas automatically go to the Republic of Nauru or Manus Island in Papua New Guinea. So it's the forcible transfer from the territory to another state to undergo refugee status determination in another country. And in Australia, all asylum seekers have been liable to removal to Nauru or PNG, even if they had characteristics warranting special consideration. So, for example, being an unaccompanied minor, a survivor of torture, none of that would exempt the mandatory transfer to offshore processing sites. The legal basis for the Australian example was simply two signed MOUs, signed in 2012 with Nauru and Papua New Guinea, respectively. They've been superseded by newer agreements, but effectively it's simply a contract whereby Australia pays poorer countries to take responsibility for their refugees, outsources their own international legal obligations under the Refugee Convention at a cost of billions of Australian dollars. And of course, more recently, just a few months ago, the UK was also considering the same model, in this case, offshoring to Ascension Island where Napoleon was detained. So is this the new way for states to conveniently shirk international legal obligations? Would this model operate outside of a state's legal obligations and so show the legal architecture to be a house of cards? The quick answer is no. States have a responsibility to fulfill their international human rights obligations. I lay out the articles in the second bullet point here. We know that from binding international instruments, and that's confirmed by the Human Rights Committee in its comment number 31. But CAT in 2014, in relation specifically to Australia, confirmed that all asylum seekers offshored by Australia should enjoy the same protection from torture and ill treatment under the convention. So the exact same provisions in terms of arbitrariness, necessity, proportionality, right to redress, right to compensation apply, which is why the Australian model has widely been deemed unlawful. But despite the Special Rapporteur against torture finding that the conditions violated the rights of asylum seekers, despite the UN High Commissioner for Refugees finding that the policy of offshoring prolonged detention is immensely harmful, it continues. And so we have a sort of diplomatic standoff that's occurring there. I want to end with a thought that broadens this out even further to a new terrain of extraterritoriality, because immigration detention has evolved yet further, perhaps now well and truly beyond the scope of the international statute books. The new trend that is popular in Europe is through externalizing border control, and so avoiding asylum seekers entering the territory, and thereby trying to avoid any ownership of responsibility for them. The case of Hirsi in 2010, the European Court of Human Rights ruled that the practice of refoulement to Libya was illegal, fine, not particularly contentious. Nevertheless, and indeed undeterred, Italy, trying to rid itself of the scourge of migrants, in 2017 endorsed a new MOU between Italy and Libya aimed at stemming irregular migrant flows. And what that meant was that Italy provided material support, money, to the Libyan border policy, so that they could better intercept the migrants themselves and establish temporary camps. So what that's meant in Libya, long a destination country for migrant workers and a key transit country, is that there's been a real surge in capacity in their detention outfits. They have formal detention centers that can house all migrants because there's a catch-all term under Libyan law where irregular stay, entry and departure have been criminalized. But they also have informal centers controlled by local armed groups, of which there are many, where migrant detainees are held for ransom or sold into forced labor. So there's a new market that's emerged where smugglers and other criminals have diversified from transporting migrants to detaining migrants, and business is booming. Add to that the alchemy of COVID-19, the closure of European ports, the closure of resettlement programs, and there's an exponential surge in capacity leading to health hazards and a huge uprise in exploitation more generally. So is this unlawful detention a shirking of Italy's responsibility? Arguably not. These aren't migrants subject to the effective control, using that legal term of art, of Italy. They're subject to the effective control of Libya. But what this demonstrates is that with every evolution of immigration detention practice, be that mandatory detention, indefinite detention, offshoring, and now externalizing, states are becoming bolder and more creative in how they design immigration detention systems, and our legal framework isn't evolving quickly enough to keep up. So as far as Italy's involvement in Libyan detention sites, the legal framework is a house of cards. It doesn't hold up. So this, the new trend that's going to be profitable for rights non-compliant and poorer southern hemisphere states, is that what we're going to see propagating the world over. I guess I'll end on saying, watch this space, rather ominous ending. Thank you.
Thank you so much, Sangeetha, also for taking us from the national to the European context and broader global context of detention practice, and also kind of answering the question of why is it that the law appears to be ineffective and replicating some of these heinous practices as well. So thanks very much for that paper. The panel is spectacularly well fitted today, and I feel it's because you not just looked at what the problems are, but identified how to address those, looked at the difficulties with the remedies. So really excited now about the